Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast, and this is a portion of our 2015 update on wills, estate planning, and probate. And one of the big changes is that for the purposes of federal, state, and inheritance tax and estate tax, the amount that someone can leave without having any federal estate tax is $5,430,000. So many people says, well, I have nothing to worry about. It goes, well, however, in New Jersey, the estate tax starts at $675,000. So even though the federal government increased the amount, New Jersey has what they consider to be a sponge tax. So they tax the difference between 675 and whatever the federal government changes it to. So therefore, it's important that if someone has assets over $675,000, they sit down with a New Jersey estate planning attorney and figure out there are ways in which to reduce the taxes, and such as setting up trusts for spouses or within the will, or if they have no spouse, setting up irrevocable trusts and putting some of the assets in the irrevocable trust ahead of time, or make gifts ahead of time. But it's not something that you should try to do yourself. Sit down with an attorney. Some of the other changes that we discussed was that for the purposes of power of attorney some years ago, that the New Jersey legislature said if it makes in a law, if it makes reference to New Jersey statute, the banks and other institutions have to honor that power of attorney. The important thing, though, is that most New Jersey attorneys do it the right way. However, if someone uses one of those cheap forms online, it doesn't make reference to New Jersey law, and a bank or brokerage house does not have to honor it. Changes with living wills. Well, there's the HIPAA law from a few years ago, and basically the doctors can't disclose information to family members unless there's something in writing. So we've revised our living wills so that it also makes a HIPAA authorization so that the doctors can discuss things with family. There have been several cases over the past couple of years dealing with what's called undue influence. And undue influence is where someone's making a change to a will, or they're doing a will that doesn't give equal distribution, and there's an issue whether or not the person who did it was controlled by, or there was undue influence. So when our office does wills and other estate planning documents, we typically want the form to be filled out by our client, and then we sit down with the client along with any family members, and we go over exactly what they want. This way we try to avoid issues where someone's contesting the will down the road. And a few other changes that people should consider is preparing something in writing, such as for funeral, burial, so that the family does what you want rather than what they want. For other information on estate planning, visit website njlaws.com. And for consult, contact the law office of Kenneth Vercammen in Edison at 732-572-0500. The materials are online on our website at njlaws.com. Thank you.